All right, today we're diving into a massive legal storm, a huge wave of challenges against a hypothetical future administration. And it all really boils down to one big question. Where's the line? How far can a president's power actually go before the courts have to step in? Let's get into it.
And this battle, it's not happening in just one place. It's being fought on so many fronts. You've got states, for instance, taking on federal policies.
Then you have private law firms saying, hey, we've been targeted, and that's not constitutional.
And on top of that, advocacy groups are in court fighting over the very definition of what it means to be an American citizen. See, each of these cases, they're like a piece of a giant puzzle, and when you put them all together, you see the bigger picture. It's a story of executive ambition clashing head-on with the legal checks and balances built into the U.S. system. And the scale here, it's just staggering. We're talking more than 100 major lawsuits. That creates this incredibly complex legal battlefield. So, to really wrap our heads around what's going on, we've got to start at the beginning and ask,
How do we even get to this point? Well, it all kicked off with a huge wave of executive orders. And, that's a pretty standard playbook for a new administration, right? They want to come in and quickly change federal policy across a bunch of different areas.
And when I say a bunch of different areas, I mean they were really broad. These orders touched on pretty much every part of American life. We're talking government spending, immigration, the federal workforce, civil rights, even environmental rules. So this wasn't just about tweaking one or two things, it was a massive top-to-bottom effort to change how things are done.
Okay, so let's take a look at a perfect example, that executive order on birthright citizenship. The administration's argument was, hey, we're just interpreting a specific phrase in the Constitution. But the challengers, and we're talking about more than 20 states here, they came back immediately and said, whoa, hold on, this isn't about interpretation. Their point was that it flew in the face of the plain text of the 14th Amendment, not to mention a Supreme Court ruling that's been on the books for over 100 years.
So you can imagine the reaction to moves like that. It was fast, it was organized, and it came from all over. The lawsuits just started pouring in. It was like the legal floodgates just burst open.
And you know what's fascinating when you look at who's filing these suits? It's the diversity. It's not just one type of group. You've got state governments, big nonprofits, professional associations like the ABA, private law firms, even news outlets. That tells you something important. This isn't just a political squabble. It's a sign that these actions were seen as affecting the entire system, from top to bottom.
Okay, so what's the actual legal playbook here? I mean, the challengers couldn't just walk into court and say, we don't like this policy. No, they had to build a case that the administration was legally overstepping its bounds, and they had a very specific set of tools to do it.
All right, probably the most important tool in their toolbox is something called the Administrative Procedure Act, the APA. The best way to think about the APA is like the official rulebook for the federal government. And in almost every single one of these lawsuits, you'll find the challengers arguing that the administration broke the rules in that book. They'll say an action was arbitrary and capricious, which is just legal speak for not based on facts or reason, or that it was flat out contrary to law.
But it wasn't just about the APA rulebook. The plaintiffs also went straight to the Constitution. They raised these huge fundamental questions. For example, does targeting a law firm violate free speech? Does freezing money that Congress already approved violate the separation of powers? Time and time again, they pointed to what they saw as a pattern of constitutional overreach, arguing that a lot of these actions just didn't follow basic due process.
So, you've got the battle lines drawn, you have the legal arguments on the table, and everything moves into the courtroom. The nation's judges are now in the hot seat, forced to decide where the limits of presidential power really lie.
And a really key thing to understand here is that this isn't a simple win or lose situation. It's more like a constant legal tug of war. Here's how it works. A judge at a lower court might hit the pause button on a policy with something called a preliminary injunction. Then, the administration will immediately appeal to a higher court, asking for what's called a stay, which is basically an order to unpause the policy. This back and forth, injunction, appeal, stay, creates this state of constant uncertainty.
And this is a fantastic example of that exact tug of war. Just look at the case involving the U.S. Agency for Global Media. It's wild. On April 22nd, a court blocks the administration's actions. Less than 2 weeks later, an appeals court pauses that block. 2 days after that, the pause is made even stronger. But wait, just 4 days later, the full appeals court jumps in and puts parts of the original block back in place. It's just total legal whiplash.
So if we take a step back and look at the big picture, what's the overall pattern? Well, obviously every case is unique, but we are seeing a trend where lower court judges are often willing to grant those first temporary blocks.
Now, that doesn't mean the case is over or that the challengers have won, but it's a really important signal. It's the judge saying, okay, the arguments here are serious enough that we need to press pause on this policy and really dig in.
And that brings us to a bigger point. This flood of lawsuits, it isn't just about one policy here or there. It's bigger than that. What we're watching is a real-time stress test of the entire American system of government, especially that delicate balance of power between the president, Congress, and the courts. And every so often, you get a moment where a court tries to draw a very, very clear line in the sand. Take this ruling, for example. The judge explicitly said that using the military for domestic law enforcement was a direct violation of a law that's been around since 1878. It's the judicial branch basically saying, hold on, executive power has limits, and those limits are set by law.
When you strip it all away, every single one of these 100-plus cases comes down to this one central conflict. On one side, you have the executive branch saying, we need the power and flexibility to act. And on the other side, you have the judicial branch saying, our job is to check if you followed the rules, if you respected the Constitution, and if you stayed in your lane.
So as all these cases play out, that central question is still hanging in the air. Where exactly is the line between a president's authority and the oversight of the courts? Yeah, there's no easy answer to that one. It's being hammered out right now, in real time. One injunction, one appeal, one court ruling at a time. And however it gets answered will define the balance of power in the U.S. for years, maybe even generations to come.